For more than a century, the Whanganui River carried more than water. It bore the weight of colonial ambition, industrial waste, and laws that treated rivers as resources to be owned, used, and controlled. But it also carried memory, the songs, stories, and whakapapa of the Whanganui iwi, and that human history would become the unlikely instrument through which a river reclaimed its rights. The story begins with contact and colonization. As European settlers established towns, farms, and mills along the Whanganui, the once pristine waters were increasingly diverted and polluted. Timber milling, river engineering, and later agricultural runoff and sewage steadily altered the river's ecology. For the Whanganui iwi, the damage was more than environmental. The river is an ancestor, an identity-forming presence that cannot be separated from the people who belong to it. Each degradation was an affront to that relationship, an erosion of cultural life and legal invisibility. Frustration turned to resistance. Throughout the 20th century, the Whanganui people challenged state decisions, sought better river management, and protested destructive projects. Those efforts met inertia and piecemeal reforms, but the deeper legal problem remained. New Zealand law treated natural features as objects, not as entities with rights. Without legal standing, the river could not speak in court, and its spiritual and communal claims were reduced to evidence rather than central claims. In 1975, a group of Whanganui elders and leaders embarked on what would become a prolonged legal and political campaign. Over decades, they pressed claims under the Treaty of Waitangi, sought protection for sacred sites, and challenged projects that threatened their water. The movement grew, interweaving whakapapa, oral history, and modern legal tactics. It was not a single lawsuit, but a long-running set of claims and negotiations that demanded a fundamental rethinking of how the law understood relationships between people and their environment. The turning point came when innovative legal advocates proposed an unusual but profound idea. If the river was, in Maori understanding, an ancestor, a living being to whom duties and respect were owed, then perhaps the law could be asked to recognize the river as a legal person. His would not be metaphor. IT would create a vehicle through which the river's interests could be represented, protected, and enforced. Non-profit attorneys and Māori leaders worked together to craft arguments that blended indigenous cosmology, human rights principles, and comparative legal precedents. Te Awa marshaled mātauranga Māori, traditional knowledge, and presented it alongside scientific evidence of ecological harm. The strategy reframed the dispute. It shifted the focus from what people could extract to what they owed. Instead of asking only for less damage, they sought legal recognition that the river itself had intrinsic rights. Advocates faced skepticism. Critics warned of absurdity. Could a river really hold rights equivalent to a human? But the coalition persisted, pointing to practical examples, guardians appointed to act on the river's behalf, obligations to consult tangata whenua, and to the moral logic of accountability. The campaign combined courtroom arguments with political negotiation, public education, and international interest in novel rights of nature approaches. In 2017, the New Zealand Parliament enacted groundbreaking legislation, Te Awa Tupua Act. The river was no longer a mere object of regulation. It was acknowledged in law as Te Awa Tupua, a legal person with rights and interests. The statute named two guardians, one appointed by the Crown and one by Whanganui iwi, to act on behalf of the river. It enshrined the river's voice into governance, required that decisions consider its health, and recognize the intertwined well-being of river and people. This legal revolution did more than settle a dispute. It embodied a radical pluralism, the state and an indigenous people accepting a vision of shared guardianship and legal innovation. It offered a practical framework to repair centuries of harm, and a moral lesson that law can evolve to reflect deeper relationships with the living world. The Whanganui River's journey from exploited resource to legal person is not an endpoint, but a model. It asks whether other societies can move beyond ownership toward responsibility, and whether courts and parliaments can accommodate voices that are not human in the conventional sense. For the Whanganui iwi, the recognition affirmed what they always knew. The river is an ancestor, and to honor it is to honor themselves. The law, in this rare and necessary moment, finally listened.